You spat in a tube. A bankruptcy court sold what was inside. More than 15 million people did this. You order a kit, you spit in the tube, you post it back. A few weeks later, a website tells you where your family came from and which cousins you never knew you had. That was the whole deal. You gave them the spit. They gave you a story about yourself. Then the money ran out. On the 23rd of March, 2025, the company filed for Chapter 11 in a federal court in Missouri. Chapter 11 is the court process where a broke company sells what it owns to pay who it owes. That same afternoon, the founder resigned as chief executive, and everything the company owned went onto a list. The word the court uses is asset. An asset is just a thing you own that somebody else might pay for. A desk is an asset. A patent is an asset. And somewhere between the office furniture and the software licenses sat the spit of 15 million people. Nobody had to do anything wrong for that. That's how the process works. So go back to the tube. It goes in the post. It lands at a laboratory. Machines pull the material out of the cells floating in your saliva and read it. Not all of it. That would cost a fortune. They read the spots where people differ. That read is called your genotype. Picture your whole genome as an enormously long book. Your genotype is a list of which word appears on a few 100,000 chosen pages. It's enough to tell you where your family came from. It's also enough to find relatives who never sent anything to anybody. They kept the sample too. Your actual spit, frozen in a rack in a room like this one. And most customers ticked a box agreeing their data could be used for research. In the company's own annual report, that's over 80% of them. 1,000 people is a curiosity. 15 million is a resource. That's the business. The kit was cheap because the kit was never the product. You were. And for a while it worked beautifully. In 2021, the company went public at a value of about $3.5 billion. Then people stopped buying kits. You only need one. There are no refills. By the autumn of 2024, the whole company was worth about $120 million. 2 days before the company filed, something quieter happened. The Attorney General of California put out an urgent warning to his own residents. Log in. Delete your data. Ask them to destroy your sample. He didn't wait for the bankruptcy. He'd read the same warnings anybody could read, and he moved first. In a bankruptcy, everything gets written down. The leases, the patents, the laboratory equipment, and the database. Once it's on that list, their job is to get the most money they can for it. That isn't cruelty. It's their legal duty. They work for the people who are owed money, and you were never one of those. 8 days after the filing, the chairman of the Federal Trade Commission wrote to the court's own watchdog. The promises a company makes about your data don't vanish when the company does. Whoever buys it, he wrote, is bound by them. The auction ran 3 days in May, 7 bidders. The opening bid was $52 million. A large American biotechnology company won it at $256 million. The runner-up was a brand new nonprofit set up by the founder who had resigned in March. Now the defense, and it's stronger than you want it to be. First, you agreed to this, not in a vague way, in a specific, written, published way. Their privacy statement said exactly what would happen if the company was sold. Here it is. If we are involved in a bankruptcy, merger, acquisition, reorganization, or sale of assets, your personal information may be accessed, sold, or transferred as part of that transaction. That's their sentence, not a lawyer's summary of it. Theirs. It sat on the website while you waited for your results. Second, look at who actually ended up with it. Not an insurance company, not an advertising company, a nonprofit research institute run by the woman who founded 23andMe in the first place. 6 months before the bankruptcy, she put a pledge in a sworn filing to the securities regulator, promising to keep the privacy policy in place. The Federal Trade Commission quoted that pledge back in March. Whatever you think of it, this isn't the nightmare version. Third, and this is the hardest one, you could delete it. The button was there, it worked, and people used it. The court heard that about 1.9 million accounts were deleted after the filing. And underneath this sits a real problem. If a company can never pass on what it holds, nobody can buy a failing company, and everything inside it dies with it. That helps nobody. Now the objection. It came from 27 states and the District of Columbia together in one filing. Their argument is one sentence long. Agreeing to give something to a company you chose is not the same as agreeing to give it to whoever buys that company later. The Attorney General of Oregon led it. His name is Dan Rayfield, and on the day they filed he said this isn't just data, it's your DNA, and that nobody handed it over thinking it would be sold to the highest bidder. 28 law offices signed on behind that sentence. If somebody steals your password, you change it. If somebody takes your card number, the bank posts you a new one. Nobody can issue you a new genome. And it isn't only yours, it describes your brother, your mother, children who haven't been born yet. A genome, the states wrote, is effectively eternal. Because that sentence hadn't always been there. The court's own examiner dated it. The word bankruptcy entered the privacy statement on the 8th of June, 2022. Before that day, it wasn't in there at all. And the company's own annual report, published in May 2024, used the word bankruptcy 0 times. So the defense works perfectly as long as you signed up after they changed it. The court appointed a consumer privacy ombudsman. That's a specialist whose only job is to tell the judge what a sale would do to the customers. A law professor from Washington University in St. Louis, Neil Richards, took it and filed 211 pages. He found the clause sat 4 clicks deep in a document of over 3,000 words cut off mid-sentence, and he would not sign it off. After the auction had closed, the founder's nonprofit came back with $305 million. The court reopened the bidding. In the final round, the biotechnology company didn't bid again. On the 27th of June, the judge approved the sale. The ombudsman had asked for consent from every customer first. The judge said no. The judge wrote that if he ordered the company to go and ask every customer for permission, it was highly unlikely that it would ever be fulfilled or even attempted. Read that twice. He wasn't saying your consent didn't matter. He was saying that asking for it properly had become impossible. If you want to know how these things actually work, subscribe. We do one of these every week. The states didn't get the ruling they asked for. They got promises with teeth instead. Permanent deletion rights, checked by state regulators. A ban on passing the data to anyone who won't follow the same rules. And a ban on sharing it with countries the government treats as adversaries. Because they'd already lost it once. In 2023, somebody walked in through the front door using passwords stolen from other websites. No clever hack. Old passwords, tried over and over. 14,601 logins worked. The company called that 0.1% of accounts, but each account was a door into other people's family trees, and the court put the number affected at about 7 million. Britain's data regulator fined them £2.31 million. Read the notice, and one sentence stays with you. The stolen files were advertised for sale online, and the seller had picked people out by their racial and ethnic background. That's what a genetic database becomes when it leaks. A list of who your grandparents were. So back to the kitchen table. You were curious about your grandmother. That's the entire thing you did wrong. And that clause isn't unusual. It's in the terms of nearly every service you use. Somewhere in each of them is a line saying that if the company is sold, you go with it. Time to rule.
Here's my ruling. On the first charge, selling what came out of the tube, not guilty. Nobody bought a tube. The judge himself said this involved customer data only in a technical sense. On the second charge, bearing the permission in the terms, guilty. The word bankruptcy was added to that policy in 2022, and millions had signed up before that. The court's own expert would not say the sale matched what those people were promised. On the third charge, losing it once already to old passwords, guilty and fined for it. On the fourth, calling it safe because a policy said so, guilty. The only people who stood up for you in that courtroom were state lawyers. And this May, one of them answered back properly. Connecticut signed a law giving you exclusive control over your own sample and your own results. It calls that your property, not an asset on somebody's list. It takes effect in October in one state out of 50. And there's one thing you can do this week. Go and look at the accounts you opened years ago and forgot about. The photo service, the old health app. Find the line about what happens if the company is sold and decide whether you still agree with it. Next time on Business on Trial, the company that spent billions buying back its own shares and filed for bankruptcy 11 months later.